the electric company in my city just decided that now was the perfect time to switch out the meter that monitors our electricity use. He's gone now, but he said it will take 30 minutes for everything to come up to speed.
Are you comfortable going forward by phone?
Yes, Your Honor, I am. I'm on my cell phone now, and it's a little bit sketchy. If the court would allow me to call from my landline?
Absolutely. We'll wait.
Okay. Okay. Give me less than 5 minutes, Your Honor. I thank you for your indulgence.
Perfectly fine.
Thank you. God, are you kidding? Are you freaking kidding me?
You're still on.
Oh, I'm sorry. I'm
sorry. We've heard that before. Could have been much worse. All right. I'm going to, well, I don't know, because the person monitoring it is not coming back on. So I think under the circumstances, I'll just stay. We should have no conversation though. I actually may just sneak out of the picture for a moment. Hello?
Yes, hello.
Is this
Petitioner MAKITA GILLIAM.
Ms. Gilliam? Okay, great.
Yes.
So you're on now, or you take your time to get ready.
I'm prepared.
Okay. All right. One moment. Okay. This is Judge Englander. And would the other counsel please introduce herself?
Good afternoon, Your Honor. Catherine Higgins-Shea on behalf of the City of Springfield.
Okay, so I have all parties, right?
Yes, sir.
Okay. This is a petition with respect to actually the granting of a waiver of the appeal bond, but then the entry of an order of payment of use and occupancy. I've read the papers, and Ms. Gilliam, you are the petitioner, so
Yes, sir.
I'll hear you.
Thank you, Your Honor, and good afternoon. My apologies for the confusion at the beginning of this hearing. As you said, my name is MAKITA GILLIAM. I am a pro se petitioner in this matter. At this time, we appear before the court and ask that this court rescind in part the lower court's order imposing monthly use and occupancy payments pending appeal in the amount of $1,000 per month, and impose a lesser amount that properly achieves a fair balance of both parties' interests. To summarize, the petitioners were shown during their argument that the amount imposed by the lower court fails in fulfilling the goal of a fair balancing of the parties' interests as laid out by the Massachusetts Supreme Judicial Court. As a brief statement of facts, Your Honor, summary process was filed by the respondents in this matter in 2019 after a ruling of judgment of foreclosure by the land court. Judgment was entered after litigation by the housing court for the respondents in July of 2021. Petitioners filed a notice of appeal and a motion to waive appeal bond, and after hearing, the lower court issued an order granting the petitioner's motion to waive appeal bond and imposing a use and occupancy monthly payment of $1,000 per month. The petitioners filed a request for review, which brings us before this court today.
So why do you think you shouldn't have to pay $1,000 per month?
The petitioners feel that an imposition of $1,000 per month as use and occupancy is not a fair and balanced consideration of both parties' interests, which is what was considered by the Supreme Judicial Court in its case, Bank of New York v. Mellon versus King, a decision of last year.
How long have you been in the property?
Almost 40 years, Your Honor. The property has been in the family for well over half a century.
How much, do you recall the amount of the unpaid taxes that led to the tax taking?
It was approximately $12,000, of which the petitioners offered to pay in full.
And I take it you are not family. You are.
I am family. I am family of the original owners, Your Honor.
Well, the original owners are the Gaskins, right?
Correct. And those were the
and
individuals
your relationship to the Gaskins is what?
My grandparents. And my co-defendant, co-petitioner is my mother. Those were her parents.
Okay, so Carol Bailey is your mother. I've got it.
Yes.
I've got it. Okay. The problem you've got, obviously, the problem you've got is you don't own the property.
Correct.
Property is owned by the city of Springfield.
Yes, sir.
So,
and the petitioners don't dispute that. The petitioners are not saying that we should be allowed to remain on the property pending appeal for nothing. Petitioners are willing to pay the city of Springfield some amount of the fair market rental value of the property. What we are saying and asking this court to find is that the amount imposed by the lower court is not a fair balancing of both parties' interests.
What do you think is the right number? Actually, don't answer the question. Don't answer the question for now.
Okay.
It's a matter for.
Okay.
Let me just hear from the city of Springfield momentarily. What's your position in this case?
Sure, Your Honor. So I think it's Ms. Gilliam gave you a little backdrop. I'll give you a smidge of that as well. The taxes started to be unpaid to the city back in 2016. The city of Springfield filed a complaint with the land court in 2018. A final judgment was issued in a tax lien case, which was recorded by the city in March 2019.
Is she right that the amount was $12,000?
I don't know that offhand, Your Honor.
Shouldn't you, when we're here talking about equity, shouldn't you know what the value of the property is and how much the city of Springfield actually was owed?
At the time of the taking, I don't, Your Honor. I do their summary process work. At some point, it probably was about $12,000. Now, through a payoff I saw during the summer, it was including taxes, interest, fees, the management costs. It was in the ballpark of 38 and change.
Would the city take that now?
So the city's position, Your Honor, is that Ms. Gilliam and Ms. Bailey are not parties entitled to redemption. So they are relatives of the former owner. That is correct. The heir at law, as determined by the Hampden County Probate Court, is the former owner, the Gaskins' son. He would be the party entitled to redemption if redemption was an option. They are not determined to be an heir. They're not interested parties entitled to redemption. They have a familial relationship with the former owners, but they're not the former owners, and they're not heirs at law as determined by the probate court.
You know what the
That's the
value of the
city.
prop, what's the appraised value of the property?
So I can tell you the assessed value. It's about 164,000, Your Honor.
Pretty good deal for the city. All right. Ms. Gilliam, you're not a
Yes, Your
record, you're not entitled to the equity of redemption. What do you say to that?
Your Honor, that is one of the main issues that the petitioner wishes to present in its appeal. Petitioners assert that redemption was implied and granted not just by the city, not just by the city's agents, but by the city's council and by the lower court. So for them to say now at this juncture that we don't have a right to redemption, or I'm sorry, Your Honor.
The lower court said that over a year ago that you didn't have those rights, right?
Yes, sir. And we argued against that in our motion for summary judgment. The court, the Honorable Judge Fine, we argued before.
But there was a probate court judgment that said that your mother didn't have any interest in the property, right?
Probate court probated a will that was left to my uncle Arthur Richard Gaskins Jr., who has had no involvement in this matter from the beginning.
Right. But he owns the property, or he
does, Your Honor, and
he owned, pursuant to a probate court order.
Yes.
He owned the property.
Correct.
And there's apparently no appeal from that order. There's no way to change that decision.
There's no way to change that, Your Honor, and the petitioners aren't saying it should be changed.
Well, but you can't argue. Well, what the judge is saying is, and I'm not offering an opinion on any of this, but I don't have a record from which I could decide it. What the city is saying and what the judge said, more importantly, is your uncle, pursuant to a probate court order, owned the property until it was taken in a tax taking. Therefore, neither your mother nor you had any rights in the property. Now,
yes, that's what.
But if you want to raise that on an appeal here, all you can appeal is the decision by the judge. I suppose you would be arguing that the judge was wrong about what the probate court judgment said. But I don't have a copy of the probate court judgment. I have none of that.
Your Honor, respectfully, we're not just going by the probate court. We're going by Judge Fields, who in his order of judgment, not in order of judgment, but in his granting of the petitioners, then defendants, motion to waive appeal bond, found that the defendants had meritorious and non-frivolous defenses.
Non-frivolous, yeah, but that standard is extraordinarily low.
I understand that, Your Honor. It was still found by the lower court.
That it was non-frivolous. Yeah, you have appellate.
That it was non-frivolous and
right, but
it was meritorious.
And
we would like the.
So, Ms. Gilliam, if I could.
Yes, sir.
The purpose of this is so that I learn things, which means that when I'm talking, you need to listen so that I can ask questions.
I apologize.
The purpose of the, I'm sorry, the judge said, yeah, you've got non-frivolous appellate arguments, but in the meantime, you need to pay $1,000 a month. That's what the judge said. And I know you've read the cases, so you're familiar with the King case, which is less than a year old, which says that there's nothing wrong with that order. So what you're really left arguing to me is that we've got non-frivolous appellate argument and $1,000 is wrong. That's an inappropriate amount for us to have to pay. Why is that inappropriate? It's not a market value?
It is a market value. However, the court in the King case considered several factors in determining the reasonableness of the amount imposed for monthly use and occupancy payments. They took under consideration specifically fair market rental value, the merits of the defense on appeal, the amount of monthly payments. In the King case, it was for mortgage going forward. In this case, it is for taxes going forward, how long the taxes weren't paid, the reasoning behind it, and the financial conditions of both parties. That is what the petitioners
Have you been
arguing.
escrowing the taxes so that you can pay them?
No, Your Honor.
Why not? Why shouldn't you have to pay at least the taxes in order to remain in the property that you claim you have rights in? Why should you be there for
respondent
free?
never requested any of that.
Well, but
The respondent never. I'm sorry.
If I might, respectfully, what you want is to live in the property free of taxes and free of any obligation to pay anything. And I'm asking
Not
you,
at all, Your Honor.
why do you think that's reasonable?
I don't think that's reasonable, and that's not
Okay.
what the petitioner is requesting, Your Honor.
Well, but you're not escrowing taxes. You're not paying any taxes. Can I ask you this?
Yes, sir.
I take it that you don't have the ability to talk to your uncle about redeeming this for $38,000?
I do have the ability to talk to him about that, Your Honor, but first, my uncle has not been involved in this matter at all.
No, I understand. I'm just, this is a practical point, okay? I'm just making a practical point. At this point, you're under an order that says if you want to stay in the property, you need to pay $1,000 a month. Otherwise, I think, I'm not sure what happens if you don't pay it. But it's probably a contempt proceeding of some sort. And there's a judgment of the court that says that you have no property rights. I've asked the city of Springfield how much is owed. They think it's around $38,000, and they acknowledge that the actual owner of the property would have a right of redemption.
Well, Your Honor, I think we acknowledged at some point he did. I think that right of redemption has since expired. I just clarifying that point. I think it's up to a year after the judgment.
So the city wouldn't take their $38,000 in taxes. They want property?
I do not believe they will. I spoke to a client this morning. I'm told that they're not going to give out another payoff on it. I was relying on a number from a payoff.
No, I know you told me you were just doing it based on something that you saw. Well,
I think the right of redemption, Your Honor, is a year, and that's since expired.
All right.
Your Honor, if I may, sir. Right
Sure.
of redemption expired a while ago, and the city still, under Judge Fine's orders, sent another payoff quote, not to Arthur Richard Gaskins Jr., who they claim had the only right to redemption, but to the defendants.
That was under Judge Fine's order
Correct.
to comply with a court order.
Correct. However, the plaintiff in that moment did not say to the court, we have no problems with sending another payoff quote, but we should send it to the party that has the right to make any decisions based on that payoff quote. They did not say that, and they did, in fact, send a updated payoff quote to the defendants.
Did you tender?
The right of redemption.
Did you?
Sorry.
Did you tender the amount in the payoff quote?
No, Your Honor, we did not.
Okay. All right. I understand.
And Judge Fine,
Sorry.
I'm sorry, Your Honor. Judge Fine subsequently said that we didn't have a right of redemption to begin with.
Right. Because there was a probate court judgment that the judge may have been unaware of at the time with respect to who has rights. The city of Springfield.
It was explained to Judge Fine in the plaintiff's argument against the defendant's motion for summary judgment.
it strikes me as a very unfortunate circumstance. The city of Springfield's position also strikes me as quite aggressive, counsel. But I understand what the position is of both parties. I'm going to take the matter under advisement. If the city of Springfield were willing to look at it from purely a reasonable dollar perspective, wouldn't be such a bad thing, counsel, in my view. All right, I'm going to hold. I'm not going to issue the order for a little while and see if you guys have a chance to talk. Okay?
Your Honor, I'm happy to relay it to my client. I think where they're coming from is that Ms. Gilliam and Ms. Bailey are not persons entitled to redemption. The person that's entitled to redemption hasn't come forward at all. You know, and
I understand that point. I
Yep.
understand the point, but you also told
And
me.
if I,
You also told
I'm
me
sorry.
moments ago that even if that person came forward at this point, the city wasn't going to
Right.
put a payoff amount on it.
correct.
And
I
she
did say
says,
that.
and she says, hey, the payoff amount was sent to us, which led to some confusion about who could. I mean, I can't get involved in the back and forth. It's not in my record before me. And I'm just saying, I'm going to take the matter under advisement. I'm not going to issue an order for a couple of days. It would be great if you guys would have a conversation. I think what you need, Ms. Gilliam, is $38,000 to have any chance. And I'm not saying the city is going to do anything anyway. They have represented that they're not inclined to. Okay?
understood, Your Honor.
All right. Thanks, folks.
Thank you, Your Honor.
Thank you.
And Ms. Gilliam, you did a great job. You really did.
I'm sorry?
You did a great job. You were as good as
Thank
any
you, Your Honor.
council, as good as any council appears before us. Well done.
I appreciate that.